Hello everyone, we are from Group 11. Our group members is Esther, Kirutika, Tharmeshwaran, Naim Nizar and Afiq Firdaus. We have got to introduce a topic of our presentation today, which is general exemptions from criminal liability. In criminal law, there are several general exemptions from criminal liability, commonly referred to as defences. These offences can absolve a defendant from liability for a crime under certain circumstances. Here are the key categories of such defences. The defendant can give excuses such as infancy, intoxication, and unsoundness. The defendant can also justify themselves with justifications such as consent, mistake, accident, necessity, threat, and private defense. Now let's move on to the topic.
Hi, my name is Tharmeshwaran. Today I'm going to explain about the general exemption of criminal liability. In that topic, I'm going to explain about the excuses infancy. A person cannot be guilty of the requisite mens rea to commit a criminal act until they have reached a predefined age of criminal responsibility. Black's Law Dictionary, Gardner 1999, defines minor as someone who has not reached full legal age. Section 82, an act of a child under 10 years of age. Nothing is an offence which is done by a child under 10 years of age. This section gives complete immunity to person under age of 10 from being prosecuted or punished for his offence. Next is Section 83, Act of a child above 10 years and under 12 years of age. Nothing is an offence which is done by a child in this age who has not attained sufficient maturity of understanding to judge of the nature and consequences of his conduct. The child will be liable if he has sufficient maturity to understand the nature and consequences of his conduct.
Created using Powtoon.
Hi everyone, my name is Muhammad Afiq. Terms insanity, which is absence of mens rea. So there's Latin word for this. Furious furor suo venita, which madman is punished by his madness alone. Furious nal voluntas, EST, which is the madman has no free will, obviously. And the third terms will be furious absentus luco EST, which is a madman like one who is absent in mentally, although physically present. So the third part will be the penal code, which is under section 84, by reason of unsoundness of mind at the execution of crime during the crime. So this is the penal code. The third one will be the explanation, which is the madman is incapable of knowing the nature of the act, whether the act is wrong and the act is contrary to the law. So that's all for this type of defense. Thank you.
Hello, my name is Muhammad Naim Mustaqim and I will be explaining about intoxication. Intoxication refers to a state where a person's mental and physical faculties are impaired due to the consumption of alcohol and drugs. There are two main types of intoxication. One is voluntary and the other one is involuntary. Voluntary intoxication occurs when an individual willingly consumes a substance, whereas involuntary intoxication happens without the individual's consent. Now let's take a look at the case study. Imagine Jane is at a party where someone secretly spikes a drink with a potent drug. Later, in her impaired state, she gets into an altercation and unintentionally injures somebody. Because Jane did not voluntarily consume the drug and was unaware of its effects, she may use involuntary intoxication as a defense.
So, for conclusion, in legal terms, infancy, unsoundness, and intoxication are important defense that can be used to reduce elements someone's responsibility for a crime. Infancy means that a person is too young to be held fully accountable under the law. Unsoundness refers to the mental illness or impairment that prevents someone from understanding their action. Intoxication, whether from drugs or alcohol, can also affect a person's ability to make decisions and control their behavior. These defenses recognize that certain conditions can affect a person's judgment and responsibility, which can impact the outcome of legal cases. Understanding these defenses is crucial for ensuring fairness in a legal system.
Talk about consent, which is another type of defense for the accused. The meaning of these terms is permission or agreement. So, according to James Stephen, an agreement freely given voluntarily by a rational person who was able to form a rational opinion upon matter which he is concerned. So, for the next part will be the section involved for this defense. We have 4 sections, which is section 87, the unintended and unknown to be likely to cause death, an act to be unintended to cause death done by consent in good faith for the advantage of person, and then section 89, which is for the benefit of a child or person of unsound mind with consent of guardian, and under section 90, which is for the benefit of a person without consent. So moving on to the next section is section 90. In this section, the must be voluntarily given, no fear of injury, no misconception of sex. Second part is the person itself. The person itself must be sound of mind, which is rational and not insane. The third part will be the capacity, which is the ability to understand the nature and consequence of the action when giving the consent. So that's all. Thank you.
Created using Powtoon.
Mistake. Penal Code Section 76. Nothing is an offence which is done by a person who by reason of a mistake of fact and not by reason of a mistake of law, in good faith believes himself to be bound by law to create. And according to Penal Code Section 79, nothing is an offence which is done by any person who is specified by law or who by reason of mistake of fact and not by reason of mistake of law, in good faith believes himself to be justified by law in doing it. So next is mistake of fact versus mistake of law. Error, existence of any such things, inadequate, wrong, forget, negligence, and superstition. So next is elements. Elements are mistake, good faith, bound by law or justified by law. So next is good faith, position of the accused, circumstances of which we acted. Section 52, nothing is said to be done or believed in good faith, which is done or believed without due care.
Next, accident. Section 80 provides a defense for action done accidentally without criminal intent if the act is lawful and done with proper care. However, if a person starts a fight and unintentionally kills a baby while hitting someone, this defense fails because unlawful act. Starting the fight and hitting people is unlawful. Next, lack of care. The person did not act with proper care and caution.
Now let's talk about the next part, which is necessity. So let's start off with the definition. The defense of necessity arises when a person commits a criminal act to avoid a greater harm or danger. To invoke necessity, 3 key elements must be present: an imminent threat, no reasonable legal alternative, and the harm caused must be less than the harm avoided. The legal standards for necessity is that the legal system assesses necessity based on whether the defendant's action were reasonable and proportionate to the threat they faced. So let's talk about a case. For example, if someone breaks into a cabin in the woods to escape a blizzard and avoid freezing to death, they may be able to use the necessity as a defense for breaking and entering.
Hello, I'm Esther and I'm back again. Now we will see about threat. Threat as a justification. Threat is a justification used when a person commits a criminal act in response to an immediate and severe threat. The idea is that the illegal action was necessary to prevent a more significant harm from occurring. Here are the key elements of this defense. First, it should be an imminent threat. The defendant must be facing an immediate and significant threat. This threat must be pressing and unavoidable, leaving no time to seek help from the authorities or use other legal means. It can be a threat of death or serious injuries. Next, no reasonable legal alternative. The defendant must demonstrate that there were no other legal means available to avert the harm. The illegal act must be only feasible option to prevent the imminent threat. Third, there is a direct causal relationship. There must be a direct connection between the defendant's action and the prevention of the threatened harm. The illegal act must effectively address and neutralize the threat. Fourth, threat directed towards the accused. The defendant can only justify himself of committing the illegal act as a defense when the threat is only directed onto himself and not on any other person. Next is voluntariness. If the defendant voluntarily placed themselves in a situation they were subjected to the threat that compelled the illegal action. If the defendant knowingly and unwillingly put themselves in a dangerous situation, they may not be eligible to claim the threat defense. The principle is intended to prevent individuals from creating or entering risky scenarios and then using the threat defense to excuse their criminal behavior. Thank you.
Ever wondered when you can legally defend yourself? The law recognizes your right to defend yourself, others, or your property from harm, but it's not a free-for-all. The force used must be reasonable and proportionate to the threat. You can defend yourself, others, and even your property, but remember, in some places you might have a duty to retreat first, if it's safe. The law around self-defense can be complex and situations can get tricky. If you ever face a situation where you need to use force, always consult an attorney to understand the law in your area. They can advise you on the specific legal principles that can apply to your situation.